Teresa got home from the ER 2 days after her crash, wondering what to say to the insurance adjuster when they called. She figured she'd be honest, tell them what happened. That was the right thing to do, right? So when the adjuster called, they were friendly, sympathetic, just checking in, and she answered every single question. How was she feeling? She said she thought she was okay. It wasn't that bad. That sentence, said on painkillers 2 days after the crash, became the centerpiece of the insurance company's case against her. Adjusters are trained to ask questions designed to produce answers exactly like that. And there's a critical distinction between your own insurance company and the other driver's insurer that most people get completely wrong. And I'm going to be straight with you. I used to be on the other side of this, and I did defense work. I represented insurance companies. I know what an adjuster is trained to do when they pick up that phone and call you. Their job is not to help you. Their job is to close your claim for as little money as possible. And that's not me being cynical. That is just the reality. They are paid to protect the company's money, and that means protecting it from you. And the thing is, they're good at it too. That friendly tone, that sympathetic voice, all that we just want to get this sorted out for you thing, that kind of energy, it's a trained technique. It works because most people want to be cooperative. They want to be reasonable, and they want to move on. So they say things they should never say. So let's talk about some of the specific phrases that will hurt your case. I feel fine. You do not say this. I don't care how you feel in the moment. Soft tissue injuries, whiplash, traumatic brain injuries don't always show up within the first 48 hours. I've had clients who felt good on day 1, day 2, and then they're in for physical therapy for 6 months. The human body goes into shock after an accident. You often don't even know what you've done to yourself yet. If you say, I feel fine on a recorded call, that statement follows your case forever. The insurance company will use it every time your injuries come up. I think the light was yellow. The moment you introduce any uncertainty about fault, you've handed the adjuster a weapon. I think is one of the most dangerous phrases in your vocabulary when you're talking to an adjuster. You don't have the accident report yet. You haven't reviewed any footage. You don't have the full picture. Don't speculate about what you think happened. Stick to what you know directly, where you were, what you saw, and what happened to your body. Nothing else. It wasn't that bad. This is the one that gets people the most. You're trying to be reasonable. You don't want to seem like you're exaggerating, so you minimize. And the adjuster writes it down. And later, when your doctor is explaining that herniated disc, the insurance company points right back to that sentence. You said it wasn't that bad. The thing is, they already knew your injuries may be serious. They're asking questions because they need you to say it wasn't bad. Don't give them that. I don't want to make this a big deal. I have heard this one more times than I can count. You are shaken up. You don't want to seem dramatic. You want to come across as a reasonable person. I get it. But when the adjuster hears it, they're not going to push back. You are signaling right up front that you will settle fast and cheap just to get this all over with. I had a client who said almost exactly this 2 days after a rear-end collision on 925. She thought she was just being polite. What she actually did was hand the insurance company a quote to build their lowball offer around. They wrote it down, and then her physical therapy bills came in a couple months later. Her own words were already in that file. Don't signal that you're easy. You don't have to be aggressive. You just have to say nothing beyond the basics. Have you already gotten a call from an adjuster in your accident? Drop a comment below and tell me what they asked you. I read them. Now here's a question that I get all the time. Do I have to give a recorded statement? And the answer depends entirely on which insurance company is asking. And that distinction is the most important thing I'm going to say in this video. If it's your own insurance company, the answer is that you actually do have to cooperate with reasonable policy-based requests. Most auto insurance policies include what's called a cooperation clause. That means you are contractually required to provide them a statement, respond to their investigation, and work with them in good faith. That is the part of the policy you signed. So if your own insurer is asking you, you do need to participate. But you can still ask to schedule the statement, review your own policy, and still speak with an attorney first. And here's what that means in concrete terms. If you refuse reasonable policy-required cooperation with your own insurance company, you can put your own coverage at risk. Your policy may require you to give a statement, provide claim-related information, sign appropriate authorizations, or even appear for an examination under oath, kind of like a deposition. In New Mexico, insurer generally has to show that you breached the material and that it was substantially prejudiced before you can be relieved of its obligations. But do not treat that as permission to stonewall your own insurer. If you are not comfortable with the request, talk to an attorney before you refuse. That's the right move. Now let's flip that. The other driver's insurance company has no contract with you, which means they have no legal basis to penalize you for staying silent. That distinction matters more than most people realize. But here's where it completely changes. If the call is from the other driver's insurance company, you have no obligation to give a recorded statement. None. That insurer represents the persons who may have caused your accident. You do not have a contract with them. You are not required to help them build their defense against you, right? I want to say that again because people miss this constantly. The other driver's insurer does not have the same rights over you like your own insurer does. Now they will try to make it sound like you're required to cooperate. They'll say it's standard procedure. They'll say they can't process the claim without a statement. That is not your problem. You can tell them politely that you'll be in touch through your attorneys, or that you're not in a position to give a recorded statement at this time. That's it. You don't owe them anything more than that. So what are you actually required to say to anyone? Here is the floor. At the scene, New Mexico law requires drivers to provide basic identifying information, including name, address, vehicle registration, and a driver's license if requested. In a later call with the other driver's insurer, keep it just as narrow. Your identity, contact information, insurance information if needed to identify the claim, and basic confirmation that you were involved. This is not the same as agreeing to a recorded statement. For your own insurance company, be cooperative. Give them the facts, the date, the location, a general description of what happened, But here's what you do not need to volunteer without a specific claim-related request: broad medical history, guesses about fault, how your injuries will turn out, or anything you're not certain of. If your own insurer later makes a reasonable policy-based request for medical records, like for authorizations tied to the claim, handle that carefully and preferably with legal advice. The rule I always tell clients is this: say what you know, don't guess, don't speculate, and don't ask for information that they have not directly asked for. Before you get on the phone with an adjuster, take 10 minutes first. Write down the basic facts while they're still clear: the date, the time, the location, what you saw, and what happened to your body. Facts only, no interpretations, no guesses. Have your own policy number ready because you'll probably need it too. And if you have already started treating with a doctor, keep that information close, but understand you do not generally have to volunteer it to the other driver's insurer before you know where your claim stands. The adjuster has done this 1,000 times, and you're probably doing it for the first time. Those 10 minutes give you a framework. They are the difference between walking to that call with your feet under you and just reacting to whatever they throw at you. Here's my strongest recommendation to anyone watching this: before you talk to any adjuster, call an attorney first, even just a quick call. Most personal injury consultations are free, including with me. I've seen the other side of this. I've sat in rooms with the adjusters. I've seen them take routine statements from honest, reasonable people and turn them into case-ending admissions. Not because those people were lying, because they were trying to be honest in a way that sounded damaging. Because they said, "I feel fine," or maybe that the light was yellow, or that it wasn't that bad. One sentence said in good faith, and the case shifts. You don't need to be deceptive. You don't need to hide anything. You just need to understand what you're walking into when that phone rings. Most people don't, right? Because nobody tells them. The adjuster calls, they sound helpful, and it feels wrong to be guarded with someone who seems to be trying to help you. And that is exactly how it is designed to feel. Their job is to close your claim. Let me put you in a position to get you what you actually deserve. If you've already spoken to an adjuster and you're worried about what you said, call me. We can talk through it. You may have more options than you think. You don't know what you don't know. And in a personal injury case in New Mexico, that can cost you a significant amount of money. If the driver who hit you had no insurance at all, the playbook changes completely. I have a video on exactly how UM and UIM claims work in New Mexico. Watch that next. If you're dealing with an adjuster right now and you're not sure where you stand, give me a call. Hudson Injury Law, 505-416-4150, or HudsonInjuryLaw.com. We do free consultations. And curious, what did the adjuster say to you after your accident? Drop it in the comments below. I want to know. Thanks and have a great day.